Welcome to StudioCF, the video law blog of the Carlton Fields Law Firm. My name is Joanna Garcia, and I'm a shareholder and business litigator at the firm. Joining me is Ellen Lyons, who is also a shareholder and business litigator at the firm. The topic for this episode is understanding Florida offers of judgment. Thank you for being here, Ellen. Can you start by telling us what are offers of judgment under Florida law?
Well, Florida law allows an offer of judgment, also called a proposal for settlement, to shift the responsibility for payment of attorney's fees onto another party. It's a very powerful tool to use in litigation.
And are they statutorily based or rule-based?
Actually, they're both. In 1986, the Florida legislature passed what is now known as the Offer of Judgment statute, and that statute has allowed for the fee shifting to occur. But the Florida Supreme Court has promulgated various rules that govern proposals for settlement, including Rule 1.442. Now, that rule says that it expressly supersedes the language of the statute. And it doesn't just say it for procedural aspects, it says it for everything. So the rule, as well as the statute, have to be considered in making any offer of judgment.
I know offers of judgment can be powerful tools to shift attorney's fees. Can you tell us why that is?
Offers of judgment are a powerful tool to shift attorney's fees because they allow an offeror who makes an offer of judgment under our Florida statute to shift their attorney's fees from the date of the offer to the end of the litigation. That can be a very significant amount of money because that includes your trial court fees and it can include your appellate court fees. And the most interesting thing about the offer of judgment statute in Florida is that it levels the playing field. Both plaintiffs and defendants can make offers of judgment. And in the case of defendants, if a plaintiff does not recover at least 75% of the amount of the defendant's offer, the defendant can shift its attorney's fees from the date of the offer to the conclusion of the litigation onto the plaintiff, and thereby eliminate a judgment entered for the plaintiff, and in fact have a judgment entered against the plaintiff for those attorney's fees. It's powerful because it creates leverage. It puts people in a position of fearing being responsible for the other side's attorney's fees, and it's often a great tool to use as part of a package of settlement negotiation tools to resolve a case.
And can you tell us how the Florida offer of judgment statute is different from the federal rule regarding offers of judgment?
Florida's offer of judgment statute is very different from Rule 68 of the Federal Rules of Civil Procedure. Rule 68 allows a defendant to make an offer of judgment to have a judgment taken against it. Now, even if that offer of judgment is made by the defendant, is not accepted, and therefore a judgment entered, even if that doesn't occur, and the defendant goes to trial, and the plaintiff recovers a judgment that is not as much as the Rule 68 offer of judgment, the only thing that really gets shifted is costs, and you have some ability to stop the plaintiff's attorney's fees. Florida's offer of judgment statute, on the other hand, is a true fee-shifting statute, and it also doesn't require that a judgment be entered by the court. It allows both parties, both the plaintiff and the defendant, to make these offers of judgment. It's powerful because it can help stop a defendant's liability for plaintiff's attorney's fees and then create a potential situation where the defendant can shift those fees to the plaintiff such that the plaintiff may even have a judgment entered against it. That's why it's very different from the federal offer of judgment statute.
Can Florida offers of judgment be served in federal court?
Yes, they can. In cases where Florida law provides the rule of decision for the claims in dispute, Florida offers of judgment under 768-79 can be served in federal court, and that's regardless of the basis of federal jurisdiction, whether it's federal question or diversity. Now, you can't serve offers of judgment as to particular counts that arise under federal question jurisdiction, but you can use them to resolve the Florida counts that are contained in federal litigation. So it's a very helpful tool. Now, when you do that, you'll want to cite both the Florida offer of judgment statute and our enabling rule, Rule 1.442. And it may seem counterintuitive to have a Florida Rule of Civil Procedure being part of a federal court litigation, but it is required, and you do need to follow the technical requirements of Rule 1442 and even reference it in the offer of judgment itself.
And how do offers of judgment work to shift a party's responsibilities for attorney's fees?
Well, let's start with the example of a defendant making an offer to a plaintiff. A defendant makes an offer to the plaintiff to settle a claim, and the plaintiff fails to recover at least 75% of that amount. And the plaintiff's recovery will include prejudgment interest, costs, and attorney's fees if they were part of the legal claim being made by the plaintiff. But if that plaintiff fails to recover at least 75% of the amount of the offer of judgment, the court has the ability to shift the defendant's attorney's fees onto the plaintiff. Now, there's going to be a lot of technical considerations that the court will look at in determining whether the offer of judgment is a valid instrument that's going to be used to shift fees. And of course, the court can always decide that the offer wasn't made with a good faith intent to resolve the case. But if you pass those hurdles, then the defendant potentially gets its fees from the plaintiff and recovers potentially a judgment against that plaintiff. Now, in the instance of a plaintiff making the offer to the defendant, the plaintiff makes the offer, and if the plaintiff recovers at least 25% more than the amount that is offered to the defendant to resolve the case, the same situation occurs where the plaintiff gets its fees and it's added to the judgment against the defendant.
Can offers of judgment be served in all cases?
No. Florida's offer of judgment statute, by its own terms, can only be used to resolve claims that are civil actions for damages, and therefore they can't be used to resolve certain kinds of claims that seek pure declaratory relief. There are also statutes that govern how both plaintiffs and defendants will get their attorney's fees, and sometimes those statutes conflict with Florida's offer of judgment. And two examples of that are employment-related statutes under Florida law and consumer-related statutes under Florida law. In some of those instances, offers of judgment cannot be used to shift fees. Now, in each instance, because every single case is different, we'll want to consult the statute and the rule and the case law to make sure that the offer of judgment is appropriately served.
What about mediation, Ellen? Can offers of judgment be used in mediation?
Well, not during the mediation process, but you can serve an offer of judgment before or after a mediation. And it creates some pressure or leverage that you might feel in the mediation. An interesting thing is that there was a Florida statute that said that a mediation order told the time to respond to an offer of judgment, but that's actually not the case. Rule 1.442 expressly supersedes that provision. So a lot of people don't know that mediation has no effect on a party's right to accept or reject an offer of judgment. It's interesting because these offers can now be used in the context of mediation either before or after, and there's no additional time for anyone to accept or reject them. It's a very nice way to structure the mediation so that either going into it or coming out of it, you've established a basis for fee shifting.
That brings us to the end of this episode of StudioCF. We hope you found this discussion informative. Please take a moment to browse our other legal topics and check back with us each month for new episodes. Thank you for watching.